crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you for joining us tonight. Got a really fascinating conversation over the next half hour. This is going to be one to remember for sure. Before we get into this and the introductions, a reminder, attorneys from Hollis Wright standing by live all throughout the program tonight. That free, confidential, and off-air conversation is yours for the taking, so take advantage of that opportunity over the next half hour. The numbers to know, text us at 205-670-1949 or call us at 844-LAW-TALK, and that is 844-529-8255. Leading our conversation, he's the managing partner of Hollis Wright, Josh Wright. Looking forward to this conversation. We're going to cover some ground tonight, aren't we?
Well, our guest, Mike Douglas, has really been a journeyman when it comes to the type and area where he started originally and where he has ended up from a legal perspective. Okay. And that's sometimes what lawyers do. And so it's going to be a really interesting conversation where we're talking about some intellectual property, a little entertainment law on the side, Mike's firm, and some of that good stuff. So first of all, we're super happy to be here. I hope you had a great week this week.
I did.
All right, good. We're just happy to be able to answer questions for people. And sometimes we come up with new and unique topics, and this is one of them. So first of all, Mike, welcome.
Josh, good to see you.
I'm glad you decided to come on and answer some questions related to intellectual property and some of the entertainment law. First and foremost, tell us a little bit about your firm, kind of how you got into this area of the law, because this is, without question, totally different than where you started your original practice.
It is. You know, in law school, I graduated in 2001. We were about the same time. You know, the area of intellectual property law existed, but it's still in its kind of nascent stages. It had not. You know, the internet had not become what it is now. Obviously, the search engines, the social media has just kind of created a different monster. And so my practice started to shift, about 4 or 5 years after I started. A good friend of mine, fortunately won American Idol, Taylor Hicks. Yeah. And, I did some work with Taylor and decided that, I probably needed to learn something about copyrights. Okay. And so I went to a CLE, and, as you know, when you graduate law school, that doesn't mean you stop learning. You have to still self-educate. And so started to go to CLEs for intellectual property specifically, and there was usually 3 or 4 people there as opposed to the hundreds of lawyers that you see at the normal ones. And I got to know some of those lawyers, and they took me in. And there's a really good community here in Birmingham of lawyers that do this type of work, and that was very helpful. It helped me realize that I could kind of get into this type of law, and so practicing with with my old firm, which is a great firm that does mostly civil defense litigation work, my practice started to sort of go in a different direction, and so I started my own law firm, Leek, Douglas and Morano. We just passed our 4-year anniversary. So
congratulations.
Yep, and
it's not easy to do.
It's not. Do you have any experience with that, Josh?
I do, and it's not easy to do, I promise.
It's not, but it's rewarding. It's a lot of fun. And it's a lot of pressure that goes along with it, obviously, but it gives you an opportunity to, if you find a niche or an area of law that you either feel passionate about or you feel like you could be good at or you could be successful at, then it's a good opportunity to if you can start your own firm, then you have some additional, I guess, opportunities that you can kind of chase instead of just kind of being confined into the
All right, so you guys, you specifically kind of focus on this area of the law, intellectual property, maybe a little entertainment law with it, but that is really a unique specialty, isn't it?
It is. In Birmingham, it is. Nashville, LA, New York, there's a lot more of it. But intellectual property law combines so many different things. My partners at my firm do, mostly business litigation work, and we do it on the defense and the plaintiff side. But when you say intellectual property, it encompasses a lot of things. You're talking about trademarks, copyrights, patents, trade secrets. And you can go on to a few other things, but those are the sort of 4 pillars of intellectual property, and really it affects every type of business. If you're a business owner, or if you're an individual who wants to write a song or a book or draw a picture. I mean, really, it affects sort of every facet of life, and certainly business. And now, with the advent of the internet, and if you search something for a name of a mover in Birmingham, and if there's one in Washington State, it's going to come up too. So we've run into this whole another world of potential legal issues and litigation that really didn't exist before.
It's funny. Mike and I have been dear friends for a long time, but we used to call him Mike Hollywood Hills Douglas when he first started out, because he really did. This is an example. In fact, we've done previous shows on this where lawyers sometimes adapt to whatever area of practice that they've got to understand that area to help clients. And that was a great example. He had a friend that started out as a singer, made it big, won American Idol, and all of a sudden Mike was thrown into this concept of, I need to understand this area of the law, and he entrenched himself in learning that, and ended up in California a bunch and doing a lot of things, learning baptism by fire, doing a really good job for his buddy, and it's a good example. Sometimes lawyers are always learning and trying to get better and better.
Yeah, and I have the background. I used to be in a band, back in high school and college, and toured around and got a really good education of what it's like to be an entrepreneur, but also I enjoy that type of thing on a personal level. And so when I realized I probably wasn't going to go to Nashville and be an actual professional musician, and I went to law school, I searched out those opportunities even then, before I knew that I was going to really pursue it. Because then there really wasn't that much to pursue. In Birmingham, there's obviously famous athletes and musicians from this area, but it's not like it is now with respect to the opportunities that come with the general intellectual property part of it.
How has the internet changed all this? It has to have changed it dramatically.
Well, it has, and if you think how interesting it is that Twitter wasn't around in 2010. That doesn't seem that long ago, or maybe it was, but it was right around then. And Instagram was after that, and so you have so many different ways that people and platforms that people have now where they can share information, and everybody's a content creator now. So we all have these little computers in our pockets, our phones, and you can use these phones to not only be a really good photographer. They shoot movies on these phones now. Right. I mean, really. Legitimate directors are filming, movies on these phones. You can also, with the search engine, like we talked about, if you search the name of one of my clients here and somebody else pops up and they're using the same name in Michigan, even if that's an accident, it's something that you have to address. Yeah. Because if you don't and you let that go, then it dilutes your intellectual property, specifically like a trademark. If it's your name, then you sort of have a responsibility. And that's why, whenever we have to deal with those situations, I try to approach it from the standpoint of, we're not trying to hurt you. If it doesn't look like it's an intentional, somebody intentionally trying to trade off your client's goodwill or brand recognition, then, what you'll do is you just say, we don't have a choice. You sort of have to get out there and police these brands, because otherwise it dilutes it, and then it gets to the point where you can't actually, protect it anymore.
I know we're getting ready to go to break. When we come back, let's talk a little bit about the differences between copyrights, trademarks, patents, and how that works in what Mike does on a daily basis.
Okay. All this talk of social media, don't forget, Hollis Wright is on Instagram, Twitter, Facebook. You can Google search Hollis Wright as well. All there, a great educational, informational resource is the law firm and its social media properties as well. Stay tuned. We've got more of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
If you need help after an accident, contact the team of attorneys at Hollis Wright.
Our law firm proudly supports Alabama high school athletics as well as the AL.com Hollis Wright Player of the Week.
Be sure to vote every week in the AL.com Hollis Wright Player of the Week fan poll.
Be sure to go vote this week for your favorite player.
Welcome back into the Attorneys. Before we hand it back to Josh to continue our conversation tonight, a reminder, attorneys from Hollis Wright standing by live. Get in touch with them. The numbers to know. Text 205-670-1949 or call them toll free 844-529-8255, 844-LAW-TALK. Josh?
All right, so Mike, talk a little bit about the difference between the various intellectual property rights, and let's kind of unwrap that a little bit.
Sure. So, like I said earlier, you have four primary types of intellectual property. You have copyrights, trademarks, patents, and trade secrets. The two that most people are going to run into are copyrights and trademarks. Patents are more so dealing with a design or a process of some kind, and to practice that type of law, we do some patent litigation work, but to file and prosecute patents, you actually have to have the patent bar. So I don't do as much of that type of work, but with copyrights and trademarks, those come up a lot and every day, and like I said, it affects every business. So a trademark is something that will protect either your name or a design. So if you think about some examples like Nike, that's the name of a company. So that would be their what's called a standard character mark, their name mark. And then obviously they have the swoosh, and that's a design mark. And so you really, you can simplify it to those, two types of trademarks that you can have. You can also have sound marks, but that's very infrequent. And so it's really, sort of limited to those two types of marks. You can also have, your name incorporated inside of a design. And so there's a lot of, different possibilities when it comes to, what you're protecting. But ultimately what you're trying to protect is your name and your brand. And we all know now, as we can see back here, the beautiful branding done by your firm, it really is, it's important because people recognize that name signifies the source of certain goods and services that you're going to get, that you can count on, that you have experience with. And so, when you start to look at, the true value in companies, if a company's going to sell, you look at, have they done the things that they need to do to protect their branding and their name? Because if those don't exist, then, there's a big flank out there where you're exposed. And somebody could come out of the blue and say, hey, by the way, you have to stop using Hollis Wright because there's a law firm here who has that federal trademark registration. And if you have a federal trademark registration, that's nationwide exclusivity. Even if they're not here using it. If they were using it prior to you using it, then they'd be able to tell you to stop. So it's important from that respect to build a company. I always tell clients, when they come in, everybody, startups, I love working with startups, and they'll come in and say, well, we've got to file, we have these names of these products, this name of the company, these designs, and I say, hang on a second. Let's start building the foundation. It's not going to be Taj Mahal tomorrow. It can be, but the first thing you need to have is your name, and you need to have your primary design, and then we can work through. I have clients that I've filed over 50 trademarks for, and I have big clients that I filed one trademark for. So it really depends on the type of industry you're in, the type of business you're doing, and so trademarks are really important. You move on to copyrights. Copyrights, protect the original work of authorship of an individual.
What's an example of like?
So a copyright can be obviously a song, a book, a movie, a screenplay, Copyrights protect a lot of different things. It can protect, certain, shapes, if you're making, certain types of pottery or art, things along those lines. And to protect a copyright, a common misunderstanding that people have is that you have to, file it with the Library of Congress to get protection. And in fact, when if we sit here and draw a picture, whether it's valuable or not, then that picture actually has copyright ownership affixed to it immediately. As soon as you affix some type of original expression of authorship to a tangible medium, then that is an actual copyright. And you get common law copyright protection from that. It is valuable to file for copyright protection with the Library of Congress. It's also very inexpensive to do so. I think the filing fee is $30. But because you get added benefits and added protection. You'll get different jurisdictional, where you can file a lawsuit if somebody infringes on your copyright. It also gives you the ability to get heightened damages if you can establish willful. The Copyright Act actually has statutorily set damage amounts. So if I prove that, Josh, you've stolen my song and you're out selling it somewhere, and I can show to a court that I sent you a letter and told you to stop doing it, and you say, well, I'm not going to, that'd be considered willful infringement, and you can be fined $150,000 for each one of those individual acts of infringement, which would mean each time that you sold one of my copyrighted works without my permission. And so you can see how it's expensive, and it's a real deterrent, and it works. You'll see that, and you saw that back, in the early 2000s in the Napster days, and that's why that shut down, because it's not sustainable. Obviously, it's a wonderful idea, and other streaming services have sort of stepped in and done it in a different way where artists are getting paid. Now, whether they're getting paid enough is a different, I guess, for a different show, but they are, getting permission and getting the licenses and paying, whereas Napster was really just taking, people's music and giving it out for free.
I got a question here about the penalty for using someone else's work, and could you be sued? And I'm curious, we're in this huge football state. It seems as though Auburn University and the University of Alabama are quite vigilant about protecting and just emblazoning something on some piece of clothing or something. They seem real protective of that. Are some companies just more diligent about that than others?
Yeah, and it's really interesting because more and more companies are becoming educated and aware of the value of protecting those brands and marks. And to bring up those two, of course, in this state, they're two of the most, if not most famous brands that this state has produced, and they are very, very vigilant. I've worked with and against both of them on different issues, and they actually use a licensing enforcement agency called the CLC in Atlanta. So they have sort of outsourced their if you're not licensed with them, then you can't sell an Alabama trademark, but it sort of homogenizes and makes the process more easy to control, because then you can make sure you have vendors and people selling your goods, because you don't want to limit it to only you can buy something at the bookstore, but you also don't want people out there saying they're going to use the Alabama A with something vulgar, so you have to have some type of quality control with that as well, and those schools and a lot of schools do a really good job with that.
When we get back, because I know we're getting ready to go to break, I want to talk a little bit about the litigation process. What happens if you tell someone to stop, you send them a cease and desist letter, they don't do it? How do you litigate from there, and what are your recourse, what's your options? And so we'll talk a little bit about that. All right,
let's step aside. Our final break of the evening. One more segment of The Attorneys coming up. Stay with us. We'll be right back.
I'm attorney John Spade with the Hollis Wright Law Firm. If you have ever had a personal injury claim, the attorney handling your case has likely told you that a portion of your settlement would have to be used to pay back your health insurance company for the medical bills that they paid relating to your injuries. This is called subrogation. In this week's Legal 411, we are answering the question, what is subrogation and how does it affect your personal injury claim? When you purchase health insurance, you sign a contract with the health insurance company, which provides that in exchange for you paying a monthly premium, the insurance company will pay your medical bills when you're injured. Now, that contract has a paragraph that gives your health insurance company the right to seek repayment for the medical bills they paid if you in turn use those medical bills as a basis to recover from a third party that caused your injury. The idea is that your health insurance company would not have had to pay your medical bills if it weren't for the wrongdoing of the third party. Now, health insurance companies routinely put attorneys on notice of their subrogation claims by outlining exactly which medical payments the health insurance company is claiming a subrogation claim for and for what amounts. Throughout the handling of your case, your attorney should be aware of the amount of subrogation your health insurance company is claiming and whether all the claimed subrogation is related to your underlying personal injury case. That way, if your case resolves, your attorney can then negotiate a reduction of the health insurance company's subrogation claim. Subrogation is one of the many moving parts that can affect your personal injury settlement and what you stand to recover. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and our promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back into The Attorneys. Just about 6 minutes remaining, so if you want to take advantage of the opportunity to speak with those attorneys standing by live for you, need to pick up the phone and give them a call ASAP. Josh?
All right, so when we went to break, I wanted to talk a little bit about, when we got back, about the litigation process. Are you involved in the litigation process when things go wrong? Yep. And if so, how are those cases? Are they filed in federal court? Are they filed in state court? How's that work generally?
Yeah, so we are. So we do, we offer, I sometimes call it a one-step intellectual property shop. So we will do from the filing to taking it through, full litigation. And that comes from my background of, being, a litigator, coming up. And so what you'll generally see is, say I have to send a cease and desist on behalf of a client because somebody is using a trademark in Michigan. And if we don't have jurisdiction over them here, then I've got to get local counsel and file a trademark infringement lawsuit and an injunction action in Michigan. If they occur here, then obviously we can bring those here. But federal court is going to be trademarks are controlled by the Lanham Act, which is federal statute, and copyright is obviously the U.S. Copyright Act, which is a federal statute. So you have a federal question, you have to make sure that you have personal jurisdiction over them. But with some of these bigger companies, that's not as difficult of a question. But yeah, that's where you're generally going to end up. With most of these fights, it's in federal court. You can have some in state court, but if they're in state court, it's usually a trade secrets case. But now there's the Federal Trade Secret Act, so you can file those in federal court now. That's been more recent. But you'll normally see it as sort of a tack-on claim. It's a business dispute, and then maybe there's a fight over a common law trademark, one that hasn't been filed with the USPTO. So, but primarily, I would say 95% of the cases that we deal with are
what
federal
can you
court.
get damage-wise? How does that work?
So it's going to depend on the type of intellectual property that's been infringed on, and really what ends up happening is you'll get to the preliminary injunction phase, which means it's at the beginning of the litigation. You've done minimal discovery, and you'll have a hearing in front of a judge. And basically, what you're asking for is for the judge to make an initial preliminary sort of decision based on what he thinks is going to be the likely outcome at the end of the case at trial. And whoever wins at that stage, unless it's a very complex case, I've had some copyright software cases that have continued on after that, but generally, if you lose at that stage, then you need to have a serious conversation with your client, because you're probably going to lose, when it comes, to that. So there's no point spending that much money. So they generally settle there. But to specifically answer your question, there's compensatory damages. Obviously, there are treble damages. There can be punitive damages if you can show willful action. And the big kicker with a lot of this are attorney's fees. And I've been on both sides of that, and that gets serious. And you start off with a small, and this is something that I always advise clients, that if we've got to consider that as a component of whether to file or whether to fight something, because it's not a lot of of the smaller firms that are doing this type of work. You're usually going to have a national firm or one of the bigger firms here, and it's expensive. And so you have to evaluate that as to how is that going to affect what our decision-making process is, because it's going to be up to the judge, of course, but they're usually going to award them. Yeah.
Most people come to you on the front end, though. They say they get a cease and desist letter. They come to you and say, hey, do I need to worry about this? I mean, is that generally how it starts? Yeah,
it either does, or the most of my business is representing rights holders who we're trying to protect their intellectual property. So I have to send out a lot of cease and desist.
Gotcha. Okay.
And then we'll try to work something out on the front end. We always try to get things worked out before it goes to litigation. And that's why I say in this area of law, it seems kind of silly to say, but I really hope there is a good lawyer on the other side who practices this type of law specifically, because they're going to know how it's more than likely going to turn out.
And just about a minute and a half remaining time enough for a final thought from both of you. And Michael, if you would, you go first, please.
Sure, I would. First of all, thanks for having me on, Josh.
Absolutely.
It's great to see you. And it's an interesting topic to me, obviously. And I would just say, it's important to recognize, what you own. And a lot of times people think of that as, a car or a house or something that you've bought, but you also own your intellectual property. And intellectual property is an extremely valuable piece of property that not a lot of people, other than more sophisticated businesses, think about. And so I would just say that's something I always consider is, do I have intellectual property that I'm not protecting right now? And if that's the case, then give us a call and we'll try to help you with it.
Yeah, and this is one of those areas of the law that our firm has no real knowledge of, and so we get guys like Mike and his firm to help us in those circumstances. And so if someone has one of those issues, if they have an intellectual property or an entertainment related law issue, they need to come to us. We'll get you to Mike and his group, and they do an outstanding job. As you can tell, super knowledgeable about the area. Yeah. First of all, thanks for, thanks for being on. Really appreciate it.
Thanks for having us.
Thank you both for being with us, and thank you as well. Always appreciate your time with us. We appreciate it. We're grateful for you, and we'll look for you next week right here on The Attorneys. Have a great week, everybody.
Thanks for watching The Attorneys, sponsored by Hollis Wright.